Man, the writing this season is just so lazy. The writers are just completely out of ideas. In investigating Trump, the DOJ sends a search warrant to Twitter, and Elon Musk personally fights it. How is this even real life? I'm gonna let Scowl deal with this one.
Thanks, Devin. Trump was permanently suspended from Twitter 2 days after the January 6th riot. His account was subsequently reinstated after Elon Musk bought Twitter, but Trump hasn't tweeted since, preferring instead his Truth Social account. On January 17, 2022, federal prosecutors working for special counsel Jack Smith applied for and received a search warrant directing Twitter to produce data and records relating to the @RealDonaldTrump account. The warrant sought a ton of information from Twitter as part of the special counsel's investigation into January 6th. The warrant was served along with a non-disclosure order, which prohibited Twitter from notifying anyone about the existence or contents of the warrant for 180 days. Prosecutors shared fears with the court that if Trump knew about the warrant, that he would jeopardize the investigation by giving him an opportunity to destroy evidence, change patterns of behavior, or notify Confederates. Twitter didn't take it so great. Twitter challenged the non-disclosure order, saying Twitter had a First Amendment right to tell Trump about the warrant because some of the records may contain materials protected under executive privilege. And then they refused to turn over the records until the issue of the non-disclosure order was resolved. Well, they lost and had to pay $350,000 in fines for contempt of court for the trouble. To understand how all this came about, we have to start with the Stored Communications Act, because the warrant to Twitter was issued under the auspices of that act. The Fourth Amendment preserves the right of the people to be secure in their persons, houses, papers, and effects against unreasonable searches and seizures by the government. A governmental seizure of personal communications generally requires the issuance of a warrant based on probable cause due to an individual's constitutionally protected reasonable expectation of privacy. Sending emails or privately messaging someone through a social media platform, however, requires the user to give information to a company that transfers, processes, and holds the user's information. The principle known as the third-party doctrine generally holds that the Fourth Amendment does not protect private information shared with third parties. So you can see the issue. If I'm using a social media platform to send messages, then maybe those messages aren't protected by the Fourth Amendment. Maybe law enforcement can get them with a simple subpoena to that provider rather than a search warrant.
You've been served. Have a nice day.
I don't like you!
The Stored Communications Act was passed in 1986 as Title II of the Electronic Communications Privacy Act. The purpose of the Stored Communications Act was to strengthen the privacy of internet users by adding a layer of statutory protections over the Fourth Amendment. It's also frankly poorly written and incredibly outdated. To put that in perspective, 1986 to 2023 is as far as 2023 to 2060. Sorry for ruining your day, millennials, but I'm one of you. The Stored Communications Act is codified in 18 U.S.C. sections 2701 through 2713. Now, we are not going to do a deep dive into the entirety of the Stored Communications Act, but a couple sections are important to understand. Section 2702 prohibits certain internet service providers from knowingly divulging customer communications and records to any person or entity. Under certain circumstances, if a service provider improperly divulges customer communications or records, that customer can sue the service provider for compensatory and punitive damages. Section 2703 identifies how state and federal governmental entities can compel providers to disclose electronic communications and records. Now, this can get pretty complicated, but a search warrant is the gold standard that compels providers to disclose stored data in virtually every case. And the section goes on to explicitly say that no provider can be sued for complying with a facially valid search warrant. Finally, Section 2705 provides the mechanism for a non-disclosure order. A governmental entity can apply for and obtain a judicial order commanding a provider to whom a warrant is directed for such period as the court deems appropriate not to notify any other person of the existence of the warrant. The court shall enter such an order if it determines that there is reason to believe that notification of the existence of the warrant will result in any of 5 enumerated harms. Those enumerated harms broadly cover endangering the life or physical safety of an individual, flight from prosecution, destruction of or tampering with evidence, intimidation of potential witnesses, or 5, otherwise seriously jeopardizing an investigation or unduly delaying a trial. Investigations that use non-disclosure orders are sometimes called covert investigations.
For your information, the Supreme Court has roundly rejected
Walter,
prior
This
restraint.
is not a first.
And yes, a non-disclosure order is a prior restraint of speech, potentially in violation of the First Amendment. For reasons we don't really need to go into, it's not entirely clear whether a non-disclosure order should be analyzed under strict or intermediate scrutiny, but even assuming strict scrutiny applies, these kinds of non-disclosure orders are generally constitutionally sound. So let's take a step back. Search warrants under the Stored Communication Act happen all the time. From both state and federal law enforcement agencies, I do them frequently. I don't just mean Twitter warrants, I mean warrants for social media and other companies that store vast amounts of digital information. Warrants to Google for emails and location information. Warrants to Meta for Facebook direct messages. These giant companies store immense amounts of information on their users, often without the users really knowing about it. And law enforcement agencies of all stripes try to get that information regularly. What's notable about these warrants is that they are two-part warrants, sometimes called hybrid warrants. Let's say you're investigating a bank robbery. If you got a search warrant for an apartment, the warrant would spell out the place to be searched, the apartment, and then the things to be seized, say bank bags, masks, or guns. If you got a search warrant for Meta, on the other hand, the two-part structure comes into play. But things to be seized has two parts. The first part commands Meta to turn over certain records, say all Facebook communication for the week before and after the bank robbery. The second part commands you, the investigator, to look through those records produced by Meta for certain information. Meta may not know what specific information you're looking for. They don't need to know. They're told, hey, turn over all these communications and that's it. You then, as the investigator, are told, look through those communications and find communications that talk about a bank robbery or guns or masks, whatever. So with all that in mind, let's talk about the special counsel's warrant for Donald Trump's Twitter account. Judge Beryl Howell signed the warrant on January 17, 2023. The warrant was sealed, meaning not available to the public, and the non-disclosure order was signed at the same time. The warrant sought a lot of information from Twitter for Trump's account, broadly in four categories. First, subscriber information, and that includes devices used to log in or access the account, IP addresses that were used to connect to the account, and all these between October 2020 and January 2021. Second, communications sent to or received by Trump's account between October 2020 and January 2021, but that includes all tweets, likes, and retweets, as well as direct messages. Third, interactions between Trump's account and other Twitter users between October 2020 and January 2021, and that includes all users who followed, unblocked, blocked, or muted Trump's account, or even who favorited, retweeted, replied, or mentioned Trump's tweets. Finally, the use of Trump's account, such as location information and all searches performed between October 2020 and January 2021. To be clear, that was the first part of the warrant, the part directed at Twitter. The second part, telling the special counsel's office what to look for in those records, has not been unsealed and was never provided to Twitter. So we don't know exactly what the special counsel was looking for in those records, although we do know generally it has to do with the January 6th investigation. And it's also worth mentioning that the second category, covering Trump's communications, is really what caused most of the commotion in this case. The warrant required Twitter to produce all of those records within 10 days, meaning by January 27th. The government tried to serve the warrant on Twitter the same day that it was signed through Twitter's legal portal website, but apparently the portal was down, which I'm sure shocks everyone after Musk took over Twitter. It took 2 days for the page to be restored, and the government was finally able to serve Twitter on January 19th. On January 25th, 2 days before Twitter had to turn over the records, the government contacted Twitter about the status of the warrant. Twitter's senior director of legal indicated that she wasn't aware of any warrant, but would make it a priority to respond. The senior director of legal also said, unsurprisingly, that producing the records in 2 days would be a tight turnaround. The next day, January 26th, the day before the records were due, Twitter notified the government that it could not comply with the warrant by the next day because it just hadn't had enough time. Fast forward to January 31st, 4 days after the deadline. Twitter indicated for the first time that it would not comply with the warrant without changes to the non-disclosure order. Specifically, Twitter wanted to notify Trump about the warrant. Bold move. A little stupid and ultimately expensive, but bold.
Now, whether you're fighting the DOJ or just your next door neighbor, you'll need a good lawyer. But if you want a great lawyer, my firm, the Eagle Team, can help. If your loved one has suffered an injury or death in the family, sexual harassment, or were involved in a car crash, we can represent you or help find you the right attorney. Just click on the link in the description for a free consultation with my team. Because you don't just need a legal team, you need the Eagle Team. Link below. Now back to Scowl.
So on February 2nd, the government moved for an order to show cause, why Twitter should not be held in contempt of court for failing to comply with the warrant. The same day, Twitter filed a motion to vacate or modify the non-disclosure order and stay compliance with the warrant. In other words, Twitter wanted to resolve the whole non-disclosure order before it turned over any records at all. So what were Twitter's arguments about why they shouldn't have to comply with the non-disclosure order and the warrant? Well, basically, Twitter argued that Trump could potentially assert executive privilege over some of what was sought by the warrant, and that Twitter had a First Amendment right to inform Trump in order for Trump to be able to assert that privilege. Their arguments were heard on February 7th in front of Judge Howell in D.C. Judge Howell was not happy. This was her warrant, after all. She signed it, which makes it an order from her court. And it's worth noting that Judge Howell spent 6 years as a federal prosecutor, and as chief judge of the U.S. District Court for the District of Columbia, she supervised the federal grand jury involved in Robert Mueller's special counsel investigation into Russian interference in the 2016 election. At the February 7th hearing, Twitter acknowledged that it did not have standing to raise Trump's executive privilege claim over the records Twitter possessed. So instead, it leaned heavily on its own First Amendment right to communicate with its customers. Twitter pointed to its policy that, for purposes of transparency and due process, Twitter's policy is to notify users, e.g. prior to disclosure of account information, of requests for their Twitter account information, including a copy of the request, unless we are prohibited from doing so, e.g. an order under 18 U.S.C. section 2705b. That policy is essential to its business model and fostering trust with its user base. Now, one could plausibly ask, okay, so how many times has Twitter actually ever filed a motion challenging a non-disclosure order given the thousands of warrants they get every year? And in fact, that's exactly what Judge Howell asked on February 7th. Twitter's attorney could not answer, saying only that he, in his own experience, had a couple of informal conversations about non-disclosure orders in the past. And after Judge Howell gave Twitter the opportunity to dig into its history and look for past instances when it had, in fact, filed challenges in court to non-disclosure orders, Twitter came back with a whopping 0. Never before in its nearly 17-year history as a company. And later, Judge Howell pushed even harder. Has Twitter found any court decision in which a third-party company like Twitter has successfully stayed compliance with a search warrant pending a First Amendment challenge to a non-disclosure order? Twitter's lawyer, no, Your Honor, not a non-disclosure order. So why this once? What's so special about this particular case? Early on, Judge Howell just straight up went for the jugular and asked, is it because the CEO wants to cozy up with the former president and that's why you're here? And later, is this to make Donald Trump feel like he's a particularly welcomed, new renewed user of Twitter here? Of course, Twitter denied that obvious truth. Twitter said that in this case, their First Amendment right to notify its user, Trump, was particularly important, though in a kind of roundabout way. Twitter noted that NARA, the National Archives and Records Administration, requested that Twitter turn over a lot of the data it stored from Trump's account over the duration of his presidency for the purposes of archiving that data as potential presidential records. Twitter suggested that the special counsel's office should just go to NARA to get what it's looking for. The government responded that 1, NARA doesn't have everything that we want. 2, that's not how search warrants work. You don't just get to tell us to go look for evidence somewhere else. And 3, pursuant to the regulations governing NARA, NARA would have to notify Trump about the request for records, and this is a covert investigation. And this was Twitter's aha moment. In one of their filings, Twitter stated that the government is attempting an end run around the statutory protections that Congress put in place regarding presidential communications, and that the statutory regime in place never contemplated and does not account for the circumstances at play here. In fact, during the February 7th hearing, Twitter's lawyer told Judge Howell, this is the first time in our knowledge that private presidential communications held by a third party were being demanded by the government through a warrant without any notice to that former occupant. We were not aware of another time ever where that has happened. Judge Howell was not impressed by that line of argument. Remember, she supervised the grand jury during the Mueller investigation, so she just had it ready to go right in front of her. And she cited the fact that the Mueller investigation obtained more than 230 orders for communications records under the Stored Communications Act, including Trump's private messages to General Mike Flynn. So no, sorry Twitter, this is not the first time this has happened. And to make matters worse, it's not like Judge Howell surprised Twitter's attorney with the Mueller investigation factoid. Twitter itself cited the Mueller investigation in its filings in order to support its own position. Sadly, Twitter's attorney proceeded to dig himself even deeper. In response to Judge Howell's comments about the Mueller investigation, Twitter's attorney said, "My understanding, Your Honor, is that the Mueller investigators were in contact with the White House counsel's office about executive privilege concerns." This mirrors Twitter's statements in a filing that the Mueller report contains potentially privileged information, but that was not obtained without notice and agreement. Again, Judge Howell had to correct him, pointing out that the only time there was notice to Trump about potential executive privilege during the Mueller investigation was when a witness was being called in to testify in person to the grand jury, in other words, where it was not covert. As Judge Howell said during the hearing, you need to read the Mueller report a little bit more carefully. Ouch. In fact, Judge Howell gave something of a painful masterclass to Twitter's attorney about how privilege actually works in a criminal investigation. She pointed out that with every single privilege, with the sole exception of Congress's speech and debate privilege, there is no advance notice requirement. Instead, material obtained covertly by the government that is potentially privileged is typically subject to a filter review protocol to identify that and get judicial rulings on that. That's exactly how it works for, say, the attorney-client privilege. If a search warrant is executed on an attorney's office, any random attorney, a special filter team combs through those documents to identify potentially privileged information. And then there's this whole process for the main investigators and prosecutors to get access to privileged information that may be relevant to and needed in the criminal investigation. This goes back to what Twitter knew and did not know. Judge Howell started the February 7th hearing by clarifying with the government attorney that Twitter hadn't seen anything more than the part of the search warrant ordering them to produce certain records. The government attorney responded, "That's correct, Your Honor. They do not know about any filter protocol that could or could not be attached to the warrant." That is a very coy way of saying, yes, there's definitely a filter team. The February 7th hearing ended with Judge Howell holding Twitter in contempt and levying a fine schedule that doubled every day. $500,000 for the first day, $100,000 for the second day, $200,000 for the third, etc. If Twitter were able to turn over the records by 5 p.m. on February 7th, there would be no fine. The contempt would be purged. Needless to say, it took Twitter 3 more days to get the records to the government. So Judge Howell ordered a total of $350,000 in fines for contempt of court, and the DC Circuit upheld that order in full. Now sure, for a company valued in the billions, $350,000 is a drop in the bucket. But with recent inflation, it might just cover a smooth shave.
Actually, shaving is really affordable with today's sponsor, Henson Shaving. Now, you all know me as the beard-wearing LegalEagle lawyer, but I'll admit there's nothing that'll get a jury more suspicious of you than looking unkempt and sloppy. So keeping my neck and cheekbones clean is of utmost importance. Or in the summer when I just shave it all off, which is where Henson comes in. For the longest time, I'd been using those insanely expensive razors with the disposable 5-blade heads, which work, but you go through the cartridges quickly and they are insanely expensive. But this is where Henson with their AL13 single-bladed safety razor comes in. They are better for the environment and better for your budget and everything else. And I can't tell any difference between the shave from Henson or the 5-bladed ones. The engineering that went into this thing is immense. The Henson AL13 razor is made using CNC machines to aerospace standards. And the razor is actually really clever. It's completely idiot-proof, and they make sure that the blade is seated 13/1000ths of an inch past the shave plane every single time because of the way it's engineered. And Henson blades only cost 10 cents, so a year's worth of shaving can only cost $3 to $5. But with my promo code, you'll actually get 100 blades free, which could last for years. And that's why Henson doesn't even try to sell you a subscription. Henson just makes a good quality razor. So if you decide that you want to invest in a quality safety razor that works and will be dramatically cheaper than the other competitors, then click on the link that's on screen right now or down in the description and select which razor you'd like out of a variety of different colors. Then use my promo code LegalEagle and you'll get 100 stainless steel double-edged replacement blades for free. So again, click on the link below and use the promo code LegalEagle to get 100 blades for free. After that, click on this link over here for more LegalEagle, or I'll see you in court.